And my lord, may I just clarify that our application is distinct. We do not seek stay, we seek an injunction.
And I'm interested in the event, my lord, it's allowed. Can we also move you again to remove it?
Orally, yeah.
No, my lord, I think in the view of Article 50, they also have a right to make that application. Your Lordship, allow me to draw your attention to Article 149 clause 1. That London is not burning, and that a vacancy is contemplated, and actually a vacancy of 74 days, in which due process ought to be initiated to ensure that a rightful person, fully qualified, fully known in law, fully appreciated by the law, takes over office. Therefore, this vacancy is a constitutional vacancy. Further to that, Your Lordship, permit me to address you that this is a new application and this application has not been determined. Further, allow me to indicate that I listen intensively to the three thematic issues that were raised by the court, and this is not one of them that was raised and resolved by the court. Finally, Your Lordship, we all have a duty to uphold the law and to defend the Constitution. On the 16th of October 1953, Fidel Castro had this to say in his defense, that history will absolve him. History will absolve the petitioners. That you have brought to your attention that you have the duty to protect the Constitution, that a person qualified should take over. And wait for the ruling. Finally, Mr. Somane has not addressed you on the qualification and the ability of a person to meet those qualifications under Article 99 and Article 97. He has not even told you that they are not applicable. If the court wants to say they are not applicable, history will absolve him. If the court wants to say that has no power to defend the Constitution, history will absolve him. If the court wants to pave way and mutilate this Constitution, history will absolve him. If the court wants to midwife an injustice, history will absolve him. I am most obliged.
My Lord, very for the ninth question. Only two issues. I invite you to Article number 23 of the Constitution, which gives parties right to come before you.
Article
23 of the Constitution, which allows parties to come before you to seek for leaves, and in this instance, you're seeking an injunction by way of a stay, albeit temporarily, of the order that this court has issued. And we're not seeking these orders in eternity. We are moving to go to the appellate court once we have the ruling. Number two, my Lord, I invite you to the application by the 9th petition, the notice of motion application dated 18th of October. Because there was an allegation that we have been sitting here as and it's coming as news that Professor Chitwekindi has been nominated as step over the conditions. Lord, that notice of motion application.
Client is a good client. Professor is a
The
good client.
application that we're making. It was taken for a conservatory order, and the court has done its decision. So we are inviting you kindly to exercise your discretion so that we may have that application processed before the appellate court, if it is found of merit, so that we don't have to have it as a parliamentary case. Thank you very much.
May it please the court. My name is Dr. Iboso, and my co-petitioner had made a similar application that that the Honorable Court be pleased to stay the order that it has given today. And the respondents have raised an issue that Professor Kindiki was nominated over a week ago, and that if we were raising this application in good faith, then we ought to have raised it earlier. I wish to refer the court to its directions, which made it clear that one, the only applications it was going to hear were the two applications that were before the court. And this was made despite protests that my co-petitioner and I have raised for the last 2 weeks, that we have applications that seek similar orders and they've not been heard. However, I also would wish to direct the court to its own directions, which directed that we file amended petitions because many of the petitions had been overtaken by time. And if you look at our petition as amended, we actually raise concern about the process of election of the deputy president designate in our amended petition. And so it is quite in substance and whatnot. Secondly, I'd like to point out that my co-petitioner pointed out that we have been feeling discriminated. And as she explained earlier, she's dyslexic and sometimes she might rush her words, especially when she's tense. The feeling of discrimination that we've been having is that out of all the petitioners, we are the ones who have consistently for the last 2 weeks called on the court to refer to the applications that are before it, and that which touch on this and will be given adequate time to ventilate them. Yesterday, I agree we were given an opportunity to speak as interested parties. And after the respondents gave their case yesterday, I tried to catch the attention of the court and I was ordered to sit down. I wasn't rising because I don't have a right of response. I know that. I was rising because I sought the discretion of the court, specifically because there are specific 4 issues that the respondents raised against the things I had raised. And in the decision of the court today, which I have listened to, one of the issues has actually turned on that. The fact that this court believes, which I believe is wrong, that it has jurisdiction to reverse the assumption of office of the deputy president. Of course, you've given your ruling and we respect it. And we wish to appeal that ruling. However, now we are asking the court, because both the respondents and us applicants agree that we have moved the Court of Appeal, and the Court of Appeal has given a mention date. So the court is aware of that, or at least that is not disputed. We are asking the court to stay its decision today, allow us to move the Court of Appeal appropriately so that it can give the necessary orders as relates to that, even if it means correcting what we believe to be the wrong finding of the court. The idea that this court is functus officio does not arise because the rules of the civil procedure, I'm not sure which rule exactly it is, allow any court, after giving its judgment, allows a party to ask for a stay even informally and the court to grant it. So really the issue of functus officio does not arise. Thank you very much.
Thank you. We will adjourn for 20 minutes. We'll be back at 5:30.